You're listening to Soundside. I'm Libby Dankman. It was seen as a test case for harsher enforcement by the Trump administration against protesters, and now there's a verdict. 3 anti-ICE protesters have been found guilty of federal conspiracy charges. The case had to do with the demonstration outside of the Spokane ICE office last June. The protest was part of a wave of anti-immigration actions that popped up across the country. The day after the protest in Spokane, the Trump administration started cracking down on immigration protests by instructing prosecutors to charge non-violent demonstrators with conspiracy. So what happens now to these convicted protesters, and what does this mean for future political marches or demonstrations? Aaron Sellers is a reporter with Range Media, which is a media organization that covers the inland Northwest. And Aaron, you were on with us last week to talk about this trial before there was a verdict. Now the verdict came down on Thursday. Good to have you back on to give us this update. Thanks for being here.
Thanks for having me.
So in total, there were 9 people charged with federal conspiracy-related charges because of this big protest in June of last year in Spokane. And ultimately, just 3 of them went to trial. Bajan Mavawala, the second, Justice for All, and Jack Archer. They chose not to take a plea deal here. And a jury on Thursday found all 3 of them guilty, but not all of them guilty of the same thing. So can you kind of walk us through what was each of these defendants convicted of?
Yes. So technically, they were all found guilty of conspiracy, but there were different counts on the charge of conspiracy. So basically, the jury instructions told the jury there's like 4 or 5 different things here that could count as conspiracy. You need to agree unanimously on which thing this defendant did. And so all of them were ultimately found guilty of conspiracy. For Jack Archer, they were found guilty of conspiring to prevent an officer from doing their duty and conspiring to injure the property of an officer to impede them in their duty, and also aiding and abetting another to conspire to impede or injure officers, which are all 3 different counts under that one charge of conspiracy. Farrell was found guilty of conspiring to prevent an officer from doing their duty, conspiring to injure the property of an officer because they were doing their duty, and conspiring to injure the property of an officer in order to impede them in their duty, and also aiding and abetting another to conspire to impede or injure officers. Bajan Mabawala II was found guilty solely of aiding and abetting the conspiracy for their role in the June 11th protest. None of them were found guilty of the count that would have said conspiring to injure an officer. So it was all of those like impeding and or injuring property elements.
You were in court for much of this trial. Tell us, how was the prosecution able to win convictions? I mean, were there any particular pieces of evidence or arguments that seemed to really sway the jury here?
Honestly, everybody in the courtroom, reporters, former lawyers, everybody was pretty shocked by the verdict. I'm unsure which pieces of evidence were able to sway them, but I know that in the prosecution's closing arguments, they made a pretty compelling case that conspiracy isn't just what you see in Ocean's 11, where people sit in a basement and make an agreement. The prosecution argued that conspiracy could also be, hey, these people show up at a thing and spontaneously there's an agreement formed, and even if we have no evidence of them making that agreement, what we do have is evidence that they acted similarly or advocated for similar things, and you should take their actions as evidence that an agreement exists. The interesting thing specifically for that aiding and abetting charge, and you're going to hear Bajan make this case, is that aiding and abetting wasn't in the original jury instructions or indictment. Mid-trial, the federal prosecutors asked the judge to add that to the final jury instructions, that if you found somebody aided and abetted the conspiracy, they can be just as guilty of committing conspiracy. And despite objections from the defense, Judge Rebecca Pennell ultimately added that aiding and abetting charge, which is the only thing that Mavawala was actually found guilty of.
So if people put out a notice on social media, which is what happened here. There were these two Venezuelan immigrants who were in the country legally, but they had some outstanding warrants. They were going to be moved from the Spokane ICE office to the Tacoma ICE detention facility. The word went out on social media. We want to show up at the Spokane office and, protest what's going on and disrupt what's happening here. Is that, according to this jury, that conversation on social media to come and protest a specific event and prevent people from being transported, is that enough to say that's a federal conspiracy count? Like, that is a federal conspiracy conviction now?
I think that's the fear for a lot of protesters. One element of the social media post is that former city council president Ben Stuckert did say, come protest, I'm going to sit in front of this bus. And the prosecution really harped on that element of sitting in front of the bus, which was later echoed by Archer, asking for people who were willing to risk arrest. And what Archer and Stuckert will tell you is that that was a call for civil disobedience. They were willing maybe to get arrested on local trespassing or failure to disperse charges. But the government is saying that ask of blocking the bus is what makes this a conspiracy to impede. It's not just an ask to protest. It's an ask to block a bus or sit in front of a bus, sit in front of a door. And that all of a sudden to them is what becomes a conspiracy.
We should mention, we talked about this last week, that the acting U.S. Attorney for Eastern Washington had resigned rather than prosecute this case, saying basically that this was typically local charges, like you said, failure to disperse, things like that protesters would face, whereas these federal conspiracy charges, this was a relatively unprecedented situation for these Spokane protesters to be facing this. So the implications here, Aaron, it sounds like, is really this distinction. Where is the line between civil disobedience and now the conspiracy to disrupt federal proceedings or federal officers? I mean, what are you hearing about the implications more widely for what happens if these convictions stand?
Yeah, look, transparently, I heard from some protesters voicing things like, well, if the penalty for peaceful protesting or civil disobedience is going to be this high, what's the incentive to protest peacefully? If the penalty is similar to protests that might be more like what people would call a riot.
Well, you might have people saying that, but I would think that there will be the cooling effect of, I don't want to catch federal charges and I'm going to stay home potentially.
Yeah, I think that it's kind of this double-sided coin where if organizing a peaceful protest can be seen as conspiracy, you either don't protest at all or you don't have an organized and peaceful protest. And people are now maybe going to be asked to choose between those two things. There is kind of a Hail Mary coming from the defense. They've filed what's called a Rule 29 motion. Before the trial, the judge basically said that she wouldn't rule before the trial on First Amendment issues and that a jury shouldn't be asked to either because First Amendment issues are the purview of the court, not the jury. But now she's willing to hear them out after the verdict. And there's a chance that she could acquit them because Archer's lawyers are arguing the things that the prosecution presented as evidence of conspiracy are things that would fall under Archer's First Amendment rights for freedom of speech. There are things that would fall under freedom of association. And so in roughly 5 weeks, the defense is going to make that case to the judge, and she will rule on whether or not they can be acquitted on a First Amendment basis. But I think there is quite a large fear in the community that people are left with only two options. Don't protest at all, or protest in an unorganized fashion without an orientation towards civil disobedience or peacefulness.
Again, the three protesters who were convicted on various types of federal conspiracy charges because of a big protest in Spokane in June of last year, Bajan Mavawala II, Justice for All, and Jack Archer. As you say, there is an appeal process going forward, and this judge is going to have a decision point in front of her. Aaron Sellers, reporter with Range Media, really appreciate your reporting on this, especially when it comes to kind of the implications for wider protest and what it means for, community members in the Seattle area, everywhere, if you're considering going out to a big protest. Appreciate your time and reporting on this for Range Media.
Thank you so much.
Thanks for listening to Soundside. Don't forget you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org or on your favorite podcast app.